Hello, everybody.
Good evening, our Patriot family, and welcome to another episode of the Fight for Patriotism, where we discuss the Constitution and how we could use it to bring our country back peacefully. On tonight's episode, we will be discussing Amendments 9 and 10 of the Constitution. I'm your producer, host, and brother ▲ and with me is your brother Angry Conservative. I'll say the Bible verse of the day, play my introduction, and then I'll check on how our brother is doing. The Bible verse of Thursday, August 11, 2022 is, "Since we live by the Spirit, let us keep in step with the Spirit." Galatians 5:25 NIV.
We need you now. We need you now. One day, one day, one day, I hope you see the truth. This puppet show stays on because of you. We've been dancing with the devil way too long. I know it's fun, but get ready to pay your dues. Oh God, come back home. This crazy world is filled with liars and abusers. We need you now before we're too far gone. I hope one day they finally see the truth. God, we need you now.
How are you doing today, brother? I'm doing pretty great today.
That's always good to know that you're doing great, my friend, and I'm doing great. Even though I've went live a couple of times today with all the freaking chaos in the federal government. That's all I'm going with. I'm not getting into that side of it, but there's enough chaos to last me a lifetime in the last week. Hello to everybody in the chat. I hope everyone in chat is doing good. And thank you for coming. Hello, Mr. Tom. Yes, what he said. What's showing on the screen, please like, subscribe, comment, and share this with all your friends and family because we need more people to know their constitutional rights. Because, hey, since I did say something about earlier, I wonder if our former president, I know our former president has used the Fifth Amendment this week, so there's something you guys can talk about that we've talked about over the last few weeks. The former president actually used the Fifth Amendment this week. So that's a good thing. So he knows his constitutional rights. So you guys need to know yours. Hey, Dakota. All right, Zach. The Ninth Amendment. Do you know what it actually means? Because I'll read it. Anyone down in chat, if you know what, after I read this, tell me what you think this means. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Does anyone in chat actually know what that means in our language today? Because I think if certain people would use the 9th Amendment, that they might be able to do something. That's all I'm going to say with it. Zach, what, and I'm going to wait for a few minutes, what it's actually saying, that 9th Amendment is actually saying, put Tom's answer up. And the example that I would use, because most of us are pro-life around here. If people that believe differently than us would say the 9th Amendment applies to that, they might actually have a leg to stand on. But people don't know their rights. So that's what most people don't realize. Hey, Polarin. But yes, that's Dakota, I'm not trying to give them ideas, but I said they might have a leg to stand on. I didn't say they would. But that's the thing about it.
People don't know their rights because our crooked school system obviously doesn't want to teach us properly.
As you can tell, I'm clapping for you. and Tom, like I said, they might have, if they use the 9th, believe me, I know all about this. That's why I brought that example up. There's a difference between it. So that's why I said what I said. I knew with the 5th Amendment that it would be overturned. Hey, joke. And now let's get on with the 9th Amendment. Very true, Dakota. Dakota, I agree with you. Hey, Cola. But let's get on with the 9th Amendment, because this is going to be a good one.
Kim from Khan Academy. Today we're learning more about the 9th Amendment to the U.S. Constitution, which reads, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." This, along with the 10th Amendment, doesn't protect a specific right, like freedom of religion or due process under the law, but rather advances an interpretation of the scope of the Constitution and of government power. To learn more about the 9th Amendment, I talked with two experts. ▏ is the E. Claiborne Robbins Distinguished Chair in Law at the University of Richmond School of Law. Jeffrey Rosen is the president and CEO of the National Constitution Center. He has written extensively on the history of the Supreme Court. Professor Lasch, can you tell us a little bit more about this amendment? Why did the framers include this amendment in the first place?
The Ninth Amendment, like the rest of the Bill of Rights, was added at the insistence of the states. Although the advocates of the proposed Constitution had claimed that the national government would have only limited enumerated power, the state ratifying conventions wanted that promise put in writing.
Originally, the Constitution didn't contain a Bill of Rights because James Madison said a Bill of Rights would be unnecessary or dangerous. Unnecessary because the Constitution itself was a Bill of Rights. It only granted Congress limited powers, and therefore Congress had no power to infringe free speech, for example, or religious liberty, and therefore wouldn't be able to do so. And dangerous, Madison said, because if you had a Bill of Rights, people might wrongly assume that if a right wasn't written down, it wasn't protected. But in response to objections by anti-federalists, that is those opposed to the ratification of the Constitution, led by George Mason of Virginia, as well as Edmund Randolph of Virginia and Elbridge Gerry of Massachusetts. So those three guys said, hey, unless we include a Bill of Rights for greater security and safety, then we don't think the Constitution should be ratified. And in response to their objections and those in ratifying conventions, many of which demanded a Bill of Rights, Madison changed his mind. And he included a Bill of Rights, which he cut and pasted from Revolutionary era state constitutions. And viewers and listeners can check those out at the Interactive Constitution. But then that raised an interpretive problem. Madison and others were worried if you just had a limited list of rights, 10 amendments in particular, protecting particular rights, people might assume that if a right wasn't written down, then it wasn't protected. And the framers didn't want you to reach that conclusion because they believe that our rights come from God or nature and not from government. Thomas Jefferson in the Declaration of Independence said we're all endowed by our Creator with certain unalienable rights.
And when you look at these amendments, our first 10 amendments, you'll notice that some address specific issues like speech and the right to bear arms. The last two amendments on that list, however, address broader issues of constitutional interpretation. These are rules of construction. The 10th Amendment declares that all powers not delegated away remain under the control of the people in the states. The 9th Amendment addresses the problem potentially raised by adding this list in a Bill of Rights. The 9th Amendment tells us that just because the Constitution lists certain important limitations on federal power, this doesn't mean that the federal government has otherwise unlimited power, or, as the 9th Amendment puts it, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage to others retained by the people. And in this way, those two last rules of construction ensure that every subject not placed under the control of the national government would remain under the control of the people in the states and remain there as a matter of right. These amendments protect the people's retained right to local self-government.
So I've talked a bit about natural rights because that same notion of the idea that you retain natural rights when you move from the state of nature to the civil society is picked up in the language of the 9th Amendment, which says that the enumeration of certain rights shall not be construed to deny or disparage others retained by the people. So one big theory of the 9th Amendment is that it refers to these natural rights that you come from God or nature and that you retain during the transition from the state of nature to civil society.
All right, so can you give us a few examples of what those unenumerated rights that people have debated have been?
The paradigmatic source for identifying what unenumerated rights are protected is a case called Corfield versus Coriell. It was decided in the early 19th century, and it was cited repeatedly by the people who wrote the Privileges or Immunities Clause to the 14th Amendment to the Constitution. And basically, the Privileges or Immunities Clause says that no state shall abridge the privileges or immunities of citizens of the United States. And the question is, what are those privileges or immunities? And in trying to define them, John Bingham, who wrote the 14th Amendment, and a lot of other people said, well, some of the privileges or immunities include the rights written down in the Bill of Rights, but others are not written down in the Bill of Rights, and you can find them in the Corfield and Coriell case. They're rights that are fundamental, they're uniform from state to state, and they've been considered basic rights of Americans from the beginning. And some of these rights include the right to make and enforce contracts, to sue and be sued, to have basic economic rights, and also to have the benefit of the writ of habeas corpus, which is in the original Constitution, and that's the right to challenge the constitutionality of your conviction. It's in the original Constitution, but not in the Bill of Rights. So those are just some examples of the unenumerated economic rights that the framers of the 14th Amendment considered to be protected by the 14th Amendment and by implication by the 9th Amendment too, because they are natural rights, as we heard Roger Sherman say, the basic rights of acquiring and possessing property and obtaining happiness and safety. Those are some of those rights.
The 9th Amendment raises the difficult issue of how exactly you determine what the rights are that are actually retained by the people. And the text of the 9th Amendment itself tells us very little about the specific content of our retained rights. But in fact, these retained rights are as numerous as the stars in the sky. They include everything from wearing a hat to walking on the sidewalk to purchasing life insurance or determining where you can park your car or what classes should be offered in the local high school. Basically everything that was never meant to be handed to the control of the national government. All of these are rights retained to the control of the people in the several states. And all of these rights will be protected if you limit the scope of federal power. A limited interpretation of the Commerce Clause, for example, preserves the people's retained right to establish local educational policy and to pass all manner of local civil rights legislation that's not expressly covered by the federal Constitution. The greater the limits on federal power, the greater the freedom of local communities. And by making a limited interpretation of federal power a right, this ensures the matter can be litigated in federal court and not just left to political compromise. Over time, courts will produce a body of law that invalidates attempts by the federal government to regulate our lives in forbidden ways, such as not having the power under the Commerce Clause to force us to purchase private health insurance, or not having the power to commandeer state officials and force them to enforce federal immigration policy.
Does this refer back to some extent to kind of the common law of England and the things that were considered the natural rights of Englishmen?
Yes, it does. Although we should distinguish, if we're going to be precise, which we should, not all of the common law rights of Englishmen were natural rights. The common law rights basically are rights that were traditionally protected by English law. They're rights that have been recognized by English judges over centuries. Natural rights come from God or nature, not from government. And there's overlap between those groups, but there might have been some common law rights of English people that were recognized by tradition, like the right to jury trial, for example. That's not a natural right because there are no juries in a state of nature. They're just people who are, imagining forming governments. So it makes it a little tricky, but it's actually not that analytically tricky. And it's so interesting that over and over again, the framer said, this is just, everyone knows what these natural rights are. They're the ones that are recognized in Corfield and Coriell. They might, and then other enumerated rights might include the common law rights of Englishmen. But it was a pretty short list. And the best way to just figure out which rights were natural, go to the interactive Constitution, click down and look at those. Look at the Virginia Declaration of Rights. Look at the Massachusetts Constitution of 1780, the New Hampshire Constitution, which has this beautiful preamble about what a natural right is. And you'll just see that all of these state constitutions are recognizing the same natural rights over and over again.
So has the Supreme Court ever decided a case based on the 9th Amendment?
The first judicial opinion was actually written by Justice Joseph Story, one of the most famous justices in American history. In his opinion in Houston against Moore, decided in 1820, Story explained that the spirit and letter of the 9th Amendment called for the limited interpreting of the scope of federal power in order to avoid interfering with state laws regarding the local militia. In fact, it wasn't until the 20th century that you find scholars and justices trying to invert the 9th Amendment in a manner that allowed or even required federal interference with local policies. In Griswold against Connecticut, for example, Justice Arthur Goldberg argued that the 9th Amendment supported the court's invalidation of state contraception laws.
Douglas says in this case that the Constitution and the particular rights in the Bill of Rights include certain penumbras formed by emanations from the particular guarantees that may create broader unenumerated rights. and privacy was one of them. Douglas says privacy is protected in different ways in different parts of the Bill of Rights. The Fourth Amendment protects our right against unreasonable searches and seizures. The Third Amendment protects the right not to have soldiers quartered in the home. The First Amendment protects a right of freedom of association. And from these particular expressions of privacy, Douglas extracted or inferred a broader and more sweeping right of privacy, which could be extended to cover our married couples' right to use contraception.
When the Bill of Rights was ratified in the late 18th century, it only applied to the federal government. It was not until after the Civil War in the late 1860s, early 1870s, that the 14th Amendment applied some of the protections of the Bill of Rights to state governments. So how does the 14th Amendment impact our understanding of the 9th Amendment?
Most constitutional historians believe that the Privileges or Immunities Clause was originally understood as applying the first 8 amendments against the states. But what of the 9th Amendment? Is it possible that the Privileges or Immunities Clause turns the 9th Amendment from a provision protecting local government to one that interferes with local government? Many libertarian scholars believe so. A close look at the historical record, however, shows that this is not likely. To begin with, John Bingham, the man who framed the Privileges or Immunities Clause, publicly declared to the House of Representatives that the Privileges or Immunities Clause made the first 8 amendments enforceable against the states. He said nothing about either the 9th or 10th Amendments. Meanwhile, in the Senate, the man who introduced the proposed 14th Amendment to his colleagues, Jacob Howard, also said that the Privileges or Immunities Clause would apply the first 8 amendments against the states, and he too said nothing about the 9th or 10th Amendments. And finally, the public that debated and ratified the 14th Amendment remained broadly committed to the Federalist principle of dividing power between the state and local governments. It had been the slave-holding rebel states that had violated this principle by demanding that slavery be enforced throughout the nation, regardless of local freedom laws. If we look at the period in which they adopted the 14th Amendment, it appears that that amendment did in fact apply the textual rights of the first 8 amendments against the states, but it left everything else to local control, subject only to the requirements of due process and equal protection.
Well, the 9th Amendment, at the very least, is a question of interpretation. It says, don't assume that if a right isn't written down, it's not protected. So when Robert Bork, the late Robert Bork, who was nominated to the Supreme Court in 1987, but didn't get through, said that the 9th Amendment should be treated as an ink blot because we can't know what rights are actually protected by the 9th Amendment. It should be ignored. That can't be right. Then that's the one thing that Madison said, don't assume that if the right isn't written down, it's not protected. But saying that that matter of construction is important and that there are certain rights not enumerated in the Constitution that are protected doesn't tell us which rights are protected. And that's where all of the action and all of the drama and all the excitement and constitutional interpretation in the 20th and 21st century has come from. How do we identify the rights that are not written down or not enumerated, but are protected? And there's a whole lot to say about that. And in fact, that's why we teach constitutional law, is to study the methodologies of interpretation that lead people to different conclusions about which unenumerated rights are protected.
So we've learned that the 9th Amendment served as an assurance that the Bill of Rights was not an exhaustive list of the rights retained by the people or the states. But how can you protect unenumerated rights, which by their very definition aren't named in the Constitution? Kurt Lash sees the original meaning of the 9th Amendment as a restriction on federal power. Jeff Rosen reminds us that although it's difficult to tell which rights the framers intended to protect with the 9th Amendment, it's likely that those rights included the same natural, unalienable rights enshrined in the Declaration of Independence. To learn more about the 9th Amendment, visit the National Constitution Center.
Now that was so. The 9th Amendment is all the rights that we have that ain't enumerated in the Bill of Rights, and a lot of them are in the Constitution. The pursuit of life, liberty, and the pursuit of happiness, that is part of the 9th Amendment. So, yes.
I believe that we need to use the 9th Amendment more because I think we need to step away from the federal bullshit. We need more natural rights rather than have the federal government to be in our lives. Sure, the 5th protects us, but the 9th helps us even more.
The 9th does do a lot for us, don't get me wrong. But I have said this I've said this to you and I've said this to other people. The one we're about to do is the second most important right we have in the Bill of Rights. It is the second one, in my opinion. People, you can disagree with me. That's why we do this. You can disagree, but that 10th Amendment, giving rights to the state, is more important than any other except for the Second Amendment. Pursuit of you can take it what you want with it, but I love how it's put in the Constitution, the pursuit of happiness. So but what do you guys think? Is the 10th Amendment the second most important amendment, or do you think it's something else? Because, like it said, because with our republic, Alan, you're right about that. They're all important. That's very true. Because it keeps us, for the most part, it keeps us away from the corruption of the federal government. That's very true, Outdoor. That's very true, Ron. Because
And to answer Dakota, I understand that we have our Second Amendment ready to go, but we don't need bloodshed. I'm sorry, but that's why I'm covering the Constitution. That helps us keep the bloodshed from happening.
And Zach, you're right about that. We do not, we will use them, but we don't want to have to use them. There's a difference between us and the people we're fighting against. We do not want to use them. We don't want to see that bloodshed. And we know. But there is a lot of things that people need to learn. So, the 10th Amendment, I will read the 10th Amendment. Zach, if you're ready for the 10th Amendment, the power is not delegated to the United States by the Constitution, nor prohibited by it to the state, are reserved to the states respectively or to the people. So in other words, the federal overreach needs to stop. That's it. The federal overreach with all these laws that should be in the hands of us needs to stop. Because if you read the opinion of the justices with the reversing of Roe, they said it should have always been in the hands of the states. It should not be a federal government issue. But yes, there are things that the states are supposed to have more power than the federal government, is what it says.
This is Kim from Khan Academy, and today I'm learning about the 10th Amendment to the Constitution, the last amendment in the Bill of Rights. The Bill of Rights was added in order to calm some of the fears held by those who felt that the new, stronger central government under the Constitution might infringe upon the powers of the states or on individual liberties. The 10th Amendment was specifically designed to allay those fears. It reads, "The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people." So what does this actually mean? To learn more, I sought out the help of some experts. Randy Barnett is the Carmack Waterhouse Professor of Legal Theory at the Georgetown University Law Center and Director of the Georgetown Center for the Constitution. Robert Shapiro is the Asa Griggs Candler Professor of Law and Dean of Emory Law School. So, Professor Barnett, can you tell us a little bit just about what that means? It's a little dense.
During the ratification debates, there was lots of opposition to the Constitution. In fact, the Constitution only was ratified after the proponents of the Constitution, who called themselves Federalists, promised that amendments would be made to the Constitution because it was the lack of a Bill of Rights and other changes that caused people to oppose it. And so they said they would put a Bill of Rights on afterwards. And at that point, in these ratification conventions started proposing amendments to Congress that accompanied their ratification. So they ratified it and they said, but here are some changes we want to see made. And one of the changes that several states asked for was wording that was very much like what became the 10th Amendment, a reaffirmation of the fact that the federal government was going to be one of limited and enumerated powers.
And the 10th Amendment is an expression of the idea that while there are more powers given to the central government of the United States,
Yeah, Zach.
We need to fight with our Constitution and not shed blood. How about instead of using our Second Amendment, we hang people publicly and set an example?
Dakota, the thing about it, we have seen over the last few years the change in the American people. If you've been watching close enough, yeah, they don't want to show it on the mainstream media, but if you watch close enough, people are coming together. Because the federal government hasn't been getting away with the things they used to get away with. People are watching now. So the bloodshed, it's not a theory. People have, believe me, since I've been doing YouTube, it's been about a year now. People have told me they have seen, they've opened their eyes to what's going on. And I'm not talking about one or two. I'm getting emails by the hundreds. That's the thing about it. We don't have to have that bloodshed. If people learn these amendments, if they learn the Constitution, things can change. Things can change in a hurry. And you've noticed for up in Virginia, which is not that far from DC, you have to think about this. Up in Virginia, they they elected someone that's not a politician. People are starting to realize. Exactly, Ellen, I mean. What? Well, we've all lived in different places. Believe me, and you're probably around liberal cities in Virginia too, is what I'm guessing, Dakota. And being that close to DC, you're seeing you're feeling the corruption a lot more than me down here in Alabama or Zach over in I think you're in Colorado, Zach, or thereabouts. So you're gonna see it a lot more than me or Zach or most of us because you live right there near DC. No, not all right. But yeah, that's the thing about it. The bloodshed doesn't have to happen. If we have to, we will do it. But people are waking up. Things are changing. For crying out loud, Joe Biden's approval rating right now is down in the 30s. What's that tell you? Put Elaine's comment up about we have to be patient, understanding, and after that one, put the other one up. And that's the thing about it. But Zach, go ahead and say what you wanted to say. I'm sorry I cut you off, my friend.
And that's why I'm starting a prepping channel. It'll be helping us come together, learn more, and they don't want that.
Zach, I know you don't like me doing this all the time, but I don't do it all that often. The best example of people learning their rights is this man that's with me. Because me and him would talk backstage after we did streams and stuff, and he would ask me about the Constitution. He's learning just as much as anybody else because yes, he gets the videos, but I'm the one and no offense, bud, I'm pretty much teaching the class about these with the help of Tom and a few others down in chat. That's the thing about it. We're trying to teach you what your rights are. It's not that we don't want the bloodshed. But that's why we do this. Zach learns as much as but that's the thing about it. We're trying to teach you what our rights are. And because we don't want to see that bloodshed. There's a reason why we've been patient. Because if you've the perfect example, Dakota, I know that, but that's a whole nother story. But the thing about it, we are learning. When Zach asked me to do this, it made me go back and look to what I remember about the Constitution. Tom helps me from time to time and gives me pointers about the Constitution because he is older than me. So I'm learning with you. Very true, V. Very true. But that's the thing about it. We're trying to bring people together. And please do not talk about the bloodshed. That's a last resort. We do not want to use that. We want to use that as a last resort. We don't want that in this country. And I think part of it, we're already in a civil war, but it's informational instead of the bullets. That's my opinion. Go ahead.
See, they want bloodshed because they want to take our Second Amendment away. So that's why I'm trying to bring you knowledge.
And put Truth with Tom up there. That will come before anything else but we're seeing people come together. Very true. For crying out loud, Wes, the state you're in, fun fact, and I'm going to use this as a fun fact time. Fun fact, during the Civil War, West Virginia was made because they wanted to go to the North. They wanted to be a part of the North. Little fun fact for everybody. Free of charge. Let's get back to the 10th Amendment.
It's still the case that the only power that the central government, the national government, can exercise are powers specifically given to it by the Constitution. So the 10th Amendment is an embodiment of the structural principle that the only powers that the national government has are those that are delegated to it in the Constitution, as opposed to the states who have general powers within their boundaries.
One of the things that I think we see in the Bill of Rights is many examples of the framers responding to particular historical evils that they had witnessed in England or in Europe more generally. So was there something in particular they had in mind they were trying to prevent with the 10th Amendment?
I think the particular evil they were concerned with was the concern of a distant, powerful, centralized government. That had been the government of King George. They wanted to make sure that wasn't the government of President George Washington. And the 10th Amendment states that the national government is not an all-powerful body with general authority to do whatever it wants. It's in line with the structure of the Constitution, which says there are certain powers given to the national government. There certainly are definite powers given to them, but only some powers. And that idea of being concerned of a distant, strong government far away from the people is really what underlies the principle of the Constitution. And that's what we see in the 10th Amendment, specifying that the powers not delegated to the United States by the Constitution are reserved to the states.
So what would you say is important about the 10th Amendment?
It reaffirms that the basic structure of the Constitution is one of limited and enumerated powers. How limited, of course, is a matter of debate, but the fact that they are limited and that all other powers are reserved to the states respectively or to the people is now a matter of constitutional law. It's a matter of the text. The other thing that's interesting about the 10th Amendment is that in Congress, they added the phrase "or to the people" at the end. The states did not propose that language. The states proposed the wording of the 10th Amendment, and it just would have stopped where it said are reserved to the states. And so that made the 9th Amendment less a states' rights provision than the states had wanted and less a states' rights provision than people read it today. So the people have rights. In fact, nowhere in the Constitution does it say anyone except individuals or persons have rights. It doesn't say states have rights. The 10th Amendment is about reserved powers, and those are the powers that the people have to govern themselves as well as other powers. And what this shows is that the people not only have rights, they also have powers. Perhaps the most important thing, however, is to note that these two are separate provisions, that the Supreme Court has sometimes read the 10th Amendment or the 9th Amendment as meaning basically the 10th Amendment, that the people have reserved powers. But we know they're different because they are put in there separately. And in fact, Madison placed a much higher premium on the importance of the 9th Amendment as opposed to the 10th.
The 10th Amendment and the 9th Amendment really speak to the the structure of the constitutional system, what it means to have a constitution setting up a national government. So the 10th Amendment is really a statement of the overall structure of what we call federalism, certain powers given to the national government and then powers reserved to the states. The 9th Amendment speaks more to the rights side of things. That is, we have certain rights which are set forth in the Bill of Rights. The First Amendment about freedom of speech and religion. The Fourth Amendment about protection against unreasonable searches and seizures. And there was some concern expressed in the late 1700s that if you specified those rights, did that somehow mean that the national government could do whatever else it wanted? And so the 9th Amendment says the enumeration of certain rights shall not be construed to deny or disparage others retained by the people. So it's in line with the idea that the national government has certain powers, but they are limited because other powers are reserved to the states. And the power of the national government may also be limited because there are rights that are reserved to the people.
How do you think the 10th Amendment tells us that the framers intended the federal government and the state governments to relate to each other?
Yeah, the 10th Amendment really is a little more about structure than about specific content. So I think the 10th Amendment embodies the idea that we should think carefully about what are the powers given to the national government, understanding that whatever is given to the national government may take powers away from the states. And so the 10th Amendment is really a text that embodies the overall principle of federalism that is implicit throughout the United States Constitution.
In fact, the 10th Amendment is in some respects kind of a replay of the first sentence of Article 1 that says that Congress only has the powers herein granted. States have the powers. By contrast, the 10th Amendment affirms that states have the powers that are not granted to the federal government, but are granted to them under state constitutions. So just as the federal government has the powers it has under the U.S. Constitution, state governments have the powers they have under state constitutions, and the people reserve all other powers to themselves.
So how has the 10th Amendment been interpreted by the Supreme Court over time? I imagine there have been some cases about this as the federal government has gotten more powerful.
Exactly. So the 10th Amendment, which really is just about the structure of government, saying some power is given to the national government, there's a concern about the power reserved to the states. The understanding of that has really evolved with the understanding of the breadth of the power of the national government. And what we've seen over the course of history in the United States is that there's been a broader understanding of the power of the government of the United States. That expansion has really come mainly in two forms. One is with regard to the government's power to regulate interstate commerce and the broad interpretation of the national government's power to regulate commerce. We saw that particularly in the context of the Great Depression, when there was viewed to be tremendous social dislocation, tremendous economic problems in the United States, to the point at which some feared that the American democracy might collapse. And the national government then was allowed to exercise more authority over the economy.
The Supreme Court in the New Deal declared the 10th Amendment as a truism, meaning as long as you find a power, then you can't have a 10th Amendment objection to that power. That's right as a logical matter, except that if you continue to expand your interpretation of those powers, then you are basically violating the spirit, if not the letter of the 10th Amendment. And finally, then, during the Rehnquist Court, until today, the Supreme Court started using the 10th Amendment to enforce the spirit of the Constitution, which preserved the existence of states, even when Congress was claiming powers that went far beyond those that were originally mentioned in the Constitution's text.
So in some cases in the early 20th century, you did see the United States Supreme Court interpreting the 10th Amendment to limit, to some extent, what the national government could do if, say, the issue were child labor or minimum wage laws, things like that. The question is that really something that the national government can do? But in the wake of, we say, the New Deal legislation that was put forward by Congress in the Great Depression of the 1930s and approved by the Supreme Court, we've seen the Supreme Court take a much narrower understanding of the 10th Amendment. Or again, we can really see the 10th Amendment in balance with the power of the national government. And as we've understood a broader role for the national government, the role reserved to the states has shrunk.
This is fascinating. So one thing that interests me about this in terms of U.S. history is the way that later on the 14th Amendment is interpreted to incorporate the Bill of Rights into the states. So how does the 14th Amendment's protection of equal citizenship rights then intersect with the idea that states have certain individual powers?
So certainly in the wake of the Civil War, we saw the 13th, 14th, and 15th Amendments, the 13th Amendment banning slavery, the 14th Amendment guaranteeing rights of national citizenship and equal protection and due process, and the 15th Amendment guaranteeing the right to vote, all of which expanded the power of the national government, and particularly the 14th Amendment and its guarantee of equal protection of laws and due process of laws were really new national restrictions on state authority, a new empowerment of the national government to protect individuals no matter in what state they were. So since the structure of the 10th Amendment is not about protecting a particular body of power, it would be natural that as the 14th Amendment expands the role of the national government, that there would be less for the states to do completely immune from federal intrusion.
The 14th Amendment represents a fundamental change to our system of federalism, precisely because it has a Section 5 in the 14th Amendment, which empowers Congress to enforce the provisions of the previous four sections, including Section 1, which has the Citizenship Clause and the Privileges or Immunities Clause and the Due Process Clause and the Equal Protection Clause. So Congress is given an enumerated power to protect individuals from their own state governments violating their fundamental rights under those Section 1 provisions. That's a change in our federalism that is consistent with the 10th Amendment, because it's a power that is delegated to Congress by the Constitution, by Section 5 of the 14th Amendment. What happened to that, however, immediately after it was enacted, is the Supreme Court decided, and I think quite consciously in their minds decided, that this change in our system of federalism was objectionable. In fact, it was the product of radical Republicans in Congress, and it really needed to be undone. And so in one of the earliest examples of what I would call living constitutionalism, the Supreme Court cut back on the powers of Congress to protect individuals from the rights of their citizens in cases like the slaughterhouse cases, or United States versus Crookshank, or Plessy versus Ferguson. These are cases, or the civil rights cases or more, in which the Supreme Court actually cut back on the scope in order to restore the federalism that existed prior to the Civil War that the justices preferred.
I think based on its text and its interpretation over time, we see the 10th Amendment really being recognition of the federalist structure of the United States Constitution, meaning there will be a national government and there will be states. And that has not changed over time. What has changed over time is an understanding about the scope of the role of the national government, how much power the national government needs, either to regulate the national economy or to protect individual rights. Certainly the interpretation of the Interstate Commerce Clause and the enactment of the 14th Amendment have been key elements in expanding the role of national power. But all of this expansion of national power is completely consistent with the language of the 10th Amendment, which again does not specify any particular kind of power reserved to the states. It just recognizes that there will be a national government and there will be states.
So how have the courts been utilizing the 10th Amendment in recent years?
In recent years, the courts have been using the 10th Amendment not so much for what it says, but for its spirit. The idea that it reaffirms the importance of states in our constitutional structure. What's happened since the New Deal is the powers of Congress under its enumerated powers have been so broadly or expansively interpreted that if they were all to be applied to states the way they are applied to private individuals and private companies, essentially, Congress could basically run all the states using its commerce power combined with its necessary and proper clause power, etc. What the Supreme Court has done in recent years is says this violates the first principles of our constitutional order, which says states are important. The 10th Amendment affirms that. And therefore, they've created certain carve-out or special protections for states from these broadly or expansively read congressional powers. None of this is really stemming from the original meaning of the 10th Amendment, because what's already happened is the original meaning of the enumerated powers has already been exceeded. But what it's attempting to do is to keep in place the balance between federal and state powers that the 10th Amendment represented, but doing so in a way that's basically modern. It's adding the states to a list of protected entities, protected from expansive federal power.
So we've learned that the 10th Amendment reaffirms that the federal government of the United States will be a limited government with enumerated powers. But as the scope of the federal government has grown, so has debate over the interpretation of the 10th Amendment. Which actions of the states can the federal government regulate, and which exceed federal power? To learn more about the 10th Amendment, visit the National Constitution Center's Interactive Constitution and Khan Academy's resources on U.S. government and politics.
So when the 10th Amendment, when that was ratified, states had more power than the actual federal government did. That says something. That says something about how our framers thought of what they wanted. And when we get to it, I'm gonna disagree with something they said in this video. That slavery was abolished. No, slavery was not abolished. That's a lie. That's a lie. It just meant that the people that weren't slaves became slaves if they went to prison. That's all it says. But yes, at the time, the states had more powers than the federal government did. And the people had more power than the states did. And does anyone have any questions about the 9th and 10th Amendments? Because this is one of those that we need people to understand that the Bill of Rights is not all 27 amendments. It's only the first 10. So please remember that. Because we will go over the other 17. Joe, I know you are, but there are people in this audience that don't know their rights, but I know you do, bud. Elaine, you're right. Ellen, you're right.
I really believe we need to bring the 10th Amendment back, because we need our states more involved.
We do, but when we get a little further down the pipe with the other 17, you will figure out why they did them when they did the other 17. You will realize that the game, because if you notice, the 11th through 27 were all enacted after a certain time in American history. There's a reason. I'm just showing you the basis. Joe, I know you're right, because me and you've had them discussions, and I love that me and you can. Put Tom's comment up because he's right. That's why me and Zach have been saying for the longest time that we need to get our local and state governments before we worry about the national. There's a reason behind us saying that stuff. Exactly, Tom. The states need to exercise their rights. But so I'm not giving up hope just yet. But yes. But this is why I love having Tom in the chat, or even up here with us, because he knows this. And Joe knows this. And Zach, you're learning this, and it's, hey, Faith. But yes, this is why we're teaching this. This is why there are times that I know I scream, and I'm sorry, but we want you guys to know these rights. We want you to live your rights. But it has come out, Tom, that they didn't know what the heck was going on. So that's a whole, and that magistrate, that's a whole nother deal that I'm not going to get in over here, but he has ties to a certain person. That's all I'm going to say with that one.
Don't give up hope because we have so much to go through, but God is on our side, and at the end, we will be together.
That's the thing. Hey, Joe, I agree with you. I agree with that statement. But Zach, thank you, my friend, for letting me do this with you, because I have fun doing this. Everyone in chat, I will look into that, Tom. But everybody, thank you for coming. Zach will say that here in a few moments, but thank you for learning about your rights under the Constitution, because we need more people to share this out so people will learn what we're allowed to do. So, but Zach, thank you. Everyone, thank you for coming. But this is why we do it. We want you guys to know your rights, because they are an important thing for all of us to know. Go ahead, Zach.
Thank you, family, for coming and learn more about your rights. We need this knowledge because knowledge beats anything that is thrown at us. Have a great night, and I love you all.
We don't trust the news, the government, or pharma. We just want freedom, that you have that to offer. We don't want the lies, the politics, or the drama. We just want the life that was promised by our fathers. We don't trust the news, the government, or pharma. We just want freedom, that you have that to offer. We don't want the lies, the politics, or the drama. We just want the life that was promised by our fathers. The man on the news says the problem